And these figures are borne out by Turkey's own figures at paragraph 106 of its memorial. Of course, it helps if you think in terms of hectares and not square metres, which always sound rather numerous. The total amount of land restored in 2006 was just over 4 hectares. In 2007, 0.6 hectares. In 2008, nothing at all, not even a square metre. An increase in 2009 to just over 31 hectares, no doubt with these proceedings in mind. But a total figure for the 4 years put together amounting to less than 0.02% of the Greek Cypriot land seized during the invasion. Sir Michael Wood says this morning, well, less than 10% asked for restitution, those who went before the Commission. Why is that? Because they and their legal advisers can read the law and they can see no point in applying for what is obviously not available. One last point on restitution. The violations complained of are continuous and result from Turkey's ethnic discrimination against Greek Cypriots prohibited by Jus Cogens. In the words of the ILC's commentary to its 2001 draft articles, restitution is of particular importance where the obligation breached is of a continuing character, and even more so when it arises under a peremptory norm of general international law. I turn to the second element of effective remedy, which is compensation for loss of use. Here too, the 2005 law is manifestly defective because it provides no freestanding right to such compensation. As you would expect from Article 159 of the TRNC Constitution, which fails, as I said earlier, to recognise the continued ownership of the applicants and those like them. Damages for loss of use are available only once the IPC has decided already, in the exercise of what seems to be a limitless discretion, either to grant restitution, to grant compensation in return for title, or to proceed with an exchange of properties. Even at that stage, there is no entitlement to damages for loss of use. Just the broad and imprecise statement that loss of income will be one of the criteria to be taken into account when calculating the overall compensation. There is no transparent calculation, indeed not even any consistency within Turkey's memorial as to how much has been paid. Compare the figures in the table at paragraph 106 of Turkey's memorial with the far smaller figures that appear in the detailed table at Annex 20 to the Turkish observations, figures that are dwarfed by the large sums of between €500,000 and €1 million paid for loss of use to Mrs. Loizidou, Mrs. Xenidis Arestis and Mr. Demades, or ordered to be paid, I should say, by this court. The third and fundamental element for an effective remedy is the quality of the law that provides for that remedy. The 2005 law lacks the legal certainty, clarity, accessibility and transparency that the Convention requires. The style of the legislation is to set out wide circumstances in which the remedies may not even be considered, and then to give the Commission a limitless discretion in other cases, so that even if the remedy is not excluded, it is made available effectively on an ex gratia basis. Such a law is utterly lacking in the legal qualities that are required. And once again, the contrast with Broniewski is stark. Turkey accepts the discretionary nature of the law. In paragraph 154 of its memorial, it states the possibility of restitution is a matter that falls within the discretion of the domestic authorities, giving appropriate weight to the present status of the property and whether third-party rights have arisen. And it takes the same line in relation to damages for loss of use. This court has said many times that a discretionary remedy cannot be regarded as an effective or sufficient one. Yet that is all that applicants to the IPC are being offered. Well, with impeccable timing, the Commission, as you've heard this morning, has started to make some large awards. We're pleased for anyone who wins the lottery. But a ticket for the lottery should not be confused with an adequate and effective remedy. We've identified many other defects in the 2005 law: the absence of any remedy for those who lost their homes but didn't own them, the absence of any remedy for violation of Article 14, the impracticality of the mechanism for exchange, involving, as it does, notional properties in the south over which neither the Commission nor the authorities in the TRNC have any power whatsoever. But important as those points are, I must pass on. So I come to my next point, that all these problems with the 2005 law are compounded when one looks at how the IPC is viewed and how it operates in practice. Turkey says at paragraph 102 that the number of applications to the IPC is rising steadily. But its own table in the same paragraph tells a different story. 197 applicants in 2007, 76 in 2008, 48 in the first 9 months of 2009. The total given by Turkey today, still only 433, less than one-third of the number which has lodged applications before this court. If it really provides an adequate and effective remedy, why this small and decreasing number of applicants? Well, as one of the applicants, Mrs. Mushiuta, has explained in a statement that you've seen, my husband fought against the Turkish invasion and occupation. I think that things speak for themselves. I do not intend to collaborate with the occupation, either directly or indirectly, nor to carry the stigma of collaboration, myself or my heirs. She was speaking there not only for herself, but for a large number of Greek Cypriots, for whom to travel to the north and submit to the jurisdiction of the occupying power is considered shameful and even treacherous. That is an attitude which government ministers have certainly from time to time reflected, but most assuredly it is an attitude that they did not create. We heard today that the government had intimidated, and we even heard for the first time that the government had harassed people into not going to the IPC. Well, there's no justification for that. If you look at the documents that Turkey itself relies upon as examples of the Greek Cypriot leadership trying to discourage applications to the IPC, Appendix 19 to its memorial, they go nothing like as far. If I can quote from the first document they rely upon, the Cyprus government recognises the right of every citizen of the Republic to use any available lawful means in order to claim the respect and application of their individual right. It points out, however, that exercising this right through the illegal IPC renders good services to the efforts of the Turkish side, and so on. So nothing at all to support what is said from the other side. The question here, the question I'm discussing now, is not one of legality, whether a remedy imposed by the occupying power is by reason of that fact alone, one that, as a matter of law, need never be exhausted. On that point, we associate ourselves fully with what Professor Lowe, QC, will say on behalf of the Republic of Cyprus. We are looking here at a point on effectiveness. If this remedy is to be adequate and effective, it must be realistic to require all those in the position of the applicants to have recourse to it. That is simply not the case, given the strength of feeling on the island and the wholly understandable reluctance on the part of some to engage in behaviour which they view as morally equivalent to collaboration with an occupying power.